Good afternoon, everyone. My name is Michael Fallings. I am a managing partner at Tully Rinckey and Tully Rinckey's Austin, Texas office. I focus my practice on employment law, both federal employment law and private employment law, specifically in the state of Texas. I've represented individuals at the EEOC and EEOC charges and different employment discrimination claims and retaliation claims. In addition, I've advised individuals in dealing with employment-related matters as far as separating from employment or any issues ongoing with the employment. I've been an attorney for about 10 years now. I've been with Tully Rinckey for about 7 years. Today, I'll be one of the presenters for this presentation regarding your protections when you're terminated in the state of Texas. I'll say that this presentation is not supposed to replace any specific legal advice for your case. And in fact, it's not giving legal advice for your specific situation. This is meant for guidance and overview on the different laws in Texas. I'll turn it over to Sean to introduce himself.
Good afternoon. My name is Sean Timmons. I'm the managing partner of our Tully Rinckey Houston, Texas office. I've been an attorney for approximately 15 years. I've been with Tully Rinckey for the last 7. I've been in private practice for over 10 years now. I've traveled up and down the state of Texas. My colleague, Mr. Fallings, handling lawsuits in federal court and state court for a variety of issues. I handle employment matters. I handle USERRA specifically as a primary practice in federal court. I also do military court martials and military litigation across the world. And with Mike, we are currently active in several lawsuits across the state, and we are actively helping to try to rectify situations for employees across the country. I'm also pro-hoc into courts across the nation. I'm licensed in New York and Colorado and the Court of Fifth Circuit in New Orleans. So we handle litigation just about everywhere. And if you'd like to talk to us in the future about your specific situation, you're happy to set up an appointment to speak with us. I'll turn it back over to my colleague, Mike, now to start the presentation. Thank you, Mike.
All right, thank you. So as far as the topics for today's webinar, as we advertised, we'll be talking about rights and protections you have for your termination in the state of Texas, specifically how to handle employment termination meeting, Texas laws that cover wrongful employment terminations, rights you have to challenge your employment termination in the state of Texas, payment of benefits that may be due to you when your employment is terminated, and any restrictions that you may have following your termination. So these are the topics we're going to be talking about today. So on that first topic, how to handle an employment termination meeting. So when an employment is terminated, typically an employer will have a meeting to inform the employee of that. So that's what we're really talking about here. First, it's important to understand that Texas is what they consider an at-will employment state. That means that the employer has the right to terminate an employee at any time for any reason, so long as those reasons are not illegal. An employer can't terminate an employee for illegal reasons. Otherwise, an employer has the right to terminate an employee's employment. But during these meetings, if your employment is being terminated, it's important to be at the meeting. Although I understand you may disagree with what's happening, it's important to be at the meeting, collect information. Ask why you're being terminated. Ask what the basis of the termination is. Ask what documents the employer has relevant to the reasons for the termination, whether it be job performance or misconduct or whatnot. At least ask that information. Even if the employer is not willing to provide it, at least you could say you've asked for that information, because if you later are challenging your termination, you could allege that your employer didn't give you this information even when requested. Ask about what benefits or payment you may be due because of your separation. Certain employees have rights regarding accrued leave that's been built up, or severance, or money that may be paid out. There's health insurance as well. You need to understand your rights as far as what benefits or payments you may do. That's especially the case if you've signed any kind of employment agreement with your employer. If you have an agreement with your employer that upon termination, you're due certain benefits, then it's important for you to have an understanding of that agreement and to go through that with your employer. And what I would also advise is, take that agreement or take that discussion, and before agreeing to anything, talk with, a representative, or just consider with, whomever you need to determine what specific rights you have. Again, closely read any clauses, that any paperwork they give you, closely read it. I would advise not to just sign something, even in a termination meeting. You could sign to acknowledge receipt, but you don't want to sign something that you're agreeing to any agreement that they're going to pay you out this amount of money, or that you're not going to, challenge your termination. You need to have that agreement, at least I would advise, of reviewed by legal counsel, or at least take, time to review what they're asking you to sign. If they're not asking you to sign just to acknowledge receipt, you need to review whatever clauses are related to your termination, or related to any benefits that you may be due. If there's any clauses that say you cannot work in a specific with a specific employer, those are called non-compete clauses, which we will talk about a little bit later. But you just need to take a look at those those documents that the employer is providing you during these termination meetings, and make sure you understand them. Make sure to follow up in writing as well, with your employer or HR representative regarding what was discussed. So there's a record of it. If there's no record of what was discussed, there's a chance that your employer will claim that they didn't say a certain, statement to you. So it's important to document, memorialize what was discussed with the HR representative, saying, this is, what you informed me today. On the date and time we had the meeting, this is who was present in the room. This is the reason you gave for my termination. This is what you asked me to sign. That's important to do. I often get a question going along with this, is whether or not, you could record meetings. I believe Texas is a one-party, consent state, meaning that just one party to the conversation needs to consent to record meetings. However, you also need to be aware of any company policies regarding recordings. Sometimes companies have recordings regarding meetings, or not allowing employees to record meetings. So it's also important to be aware of that, even during a termination meeting, because you may think during a termination meeting, well, I'm being terminated, so it doesn't matter what I do. Well, it could. You don't want to have a termination meeting turn into another allegation of misconduct, which the employer could use in any kind of challenge you're making to your termination meeting. So although it's a understandably difficult situation, it's important to remain professional during this time, but still reserve your rights to challenge your termination if you deem that necessary. The next slide we'll talk is Texas laws covering employment terminations, and my colleague Sean's going to cover this slide.
Well, good afternoon, everyone. I hope everybody's following along here. Bottom line, there's several federal laws that are applicable. Let me talk about Texas specifically. Texas is a very, politically conservative state, which is pro-employer, and the Fifth Circuit is also very conservative. I think it's the most conservative appellate court. So there isn't, in New York, there's like a New York Human Rights Statute, New York Human Rights Commission. In California, there's something similar. There's a lot of state protections on top of federal law in those individual jurisdictions, New York, California. Texas does not have anything equivalent to that. So in Texas, you're really just left with the federal minimum, meaning we still have, minimum wage is $7.25 an hour in Texas. We don't have a supplement beyond that. Most states have raised their minimum wage. Texas still follows the federal minimum. Well, it's the same thing with employment rules. Title VII prohibits discrimination. It was passed about 60 years ago, 1964. And this law prohibits discrimination based on race, color, religion, national origin, sex, sexual orientation. It's been expanded, and it also covers prohibitions on sexual harassment and other forms of workplace misconduct. It prohibits the retaliation against individuals who make a legitimate claim of discrimination, and it prohibits, taking steps to, engage in reprisal against somebody who makes a good faith complaint. There's other federal statutes, the Uniform Services Employment Reemployment Rights Act, also known as USERRA, which was originally passed in the 1940s in response to World War II, and it's been expanded considerably over the last 80 years. Every year, they seem to add legislation to improve the statute and provide additional guidance and additional amendments. There is bipartisan support for veterans, and members of Congress love to do a press release talking about how much they love veterans, so they usually add a piece to USERRA every year, calling it the 2019 Veterans Improvement Act as an example. There's the Texas Whistleblower Act under Texas Government Code, Section 554, which is a Texas-specific law in addition to federal protections that protects government employees, public employees, reporting internal corruption. So if a DPS trooper or a teacher reports misconduct or waste, fraud, and abuse and faces retaliation, that would be a violation of Texas government code and would potentially entitle someone to seeking a recovery in the court system. Federal laws, in addition to what we've discussed already, also include Age Discrimination Employment Act, meaning individuals who are over 40 cannot be automatically replaced exclusively based on age to bring in younger people. That was a problem, especially in the manufacturing sector, where if somebody was older, they would be considered to be deficient and now replaced with somebody younger who is maybe faster and more physically mobile. Well, if you're still able to perform the essential functions of the job, you can't be discriminated against based on age. Same thing with the Americans with Disabilities Act. It was originally passed about 30 years ago under the first administration of the first Bush presidency. And that law was designed to protect individuals who are wheelchair bound, to still give them an opportunity to do jobs where they can perform the essential functions. Obviously, if you have medical limitations, such as a wheelchair, you might not be able to lift boxes, but if you could still do 90% of the functions of a position, you should be given consideration for that job. If you become disabled while you're employed, you generally have a duty to inform your employer of disability if you intend to invoke the protections of the statute. So this is key, because if you come after the fact and say, oh, well, I have depression, that's why my performance was deficient, you actually have a duty as an employee to notify your employer of your condition to invoke the protections of the act. Family Medical Leave Act entitles individuals who meet a certain threshold requirement of 1 year of employment to take unpaid leave for eligible events such as medical illness in a member of their family, childbirth. There's other provisions that allow use of FMLA to care for a sick child. Again, each of these protections are also dependent on the size of an employer. So Title VII requires a certain number of employees for the statute to be applicable. The only one here that does not matter the size of the employer is USERRA. USERRA could be 2 employees and the company's liable, whereas each other statute has a certain threshold, whether it's 15, 25, 50. Each law has different requirements. So the idea there was a mom and pop bakery that's run by, say, Chinese national. They want to keep it within the family. They can affirmatively discriminate and keep it within the family and not hire outside individuals under Title VII, because there's like a small business exception. That's why it requires a certain number of employees. That was a compromise when they crafted this legislation. So there are, restaurants and other small businesses that may be exclusively family operations, and that would be lawful. They don't have to consider outside individuals. But generally, if it's an employer that's large enough, they have to comply with Title VII and the rest of these statutes. Now, if somebody is an at-will employee and they're terminated, but they believe that the termination was actually based on a protected characteristic, such as they were being mocked for their faith, or they were being harassed about their race, or maltreated because of their national origin, or any combination of all those factors, they can bring a claim and fight their termination and say, look, this was not legitimate. There's a couple ways to prove under Title VII. There's direct evidence, emails, verbal statements, witnesses to verbal statements. Using vile, racist language would be an example of direct evidence. Thankfully, we don't see that as common as it was maybe in prior generations. So the courts have developed a new test to allow individuals to bring discrimination claims when you don't have explicit direct evidence. There's no requirement to have direct evidence. You can imply evidence, such as everybody being denied a promotion is one particular race, and everybody getting treated better is a different race. You can infer that's based on a violation of Title VII because people are being treated differently based on their racial characteristics, which is a prohibition and not permissible under the law. The way you would establish that is you bring a prima facie case, show, okay, me and two other comparators were maltreated. We fit this criteria. The company would then come forward with a response saying, oh, actually, we have a legitimate non-discriminatory reason, had nothing to do with race, had everything to do with the fact that they all were deficient in their job. You then would have to show, well, that excuse is subterfuge and a cloak to cover the discrimination. Then the claim would move forward. And ultimately, much of this could face the disposition of a jury. A jury would have to decide who's telling the truth and who's not. Obviously, cases get resolved before they get to a jury through litigation and mediation and alternate dispute resolution. But at the end of the day, I also want to point out Title VII looks pretty strong on paper, but it's not as strong as it may appear. For example, a prohibition on sexual harassment in the workplace is unlawful. However, if an individual engages in behavior that's obnoxious and absurd and quite crass, it doesn't necessarily mean the employer is going to be responsible. The employer can escape responsibility by saying, well, we gave Mr. Jones training. We made him watch the videos and we told him not to sexually harass anybody. We had no way to know he was going to sua sponte, make inappropriate comments, inappropriate remarks. The other exceptions would be the court, especially the Fifth Circuit, will say, oh, well, it was just a one-time lone event, or it was only a couple of times, and it was a comment on appearance alone, and wasn't that big of a deal. So the court's, lack of better description will say, so what? That's quite unfair and quite, demoralizing to know, but that's the reality we have to work within when it comes to litigating these cases, especially when we have Fifth Circuit review. So the best way to prove the merits of your case is documentation. Think of anything that could be used in the future as an evidentiary exhibit: emails, photographs, statements from witnesses, contemporaneous notes at the time the events occurred. Don't wait years to bring forward information either. Report violations immediately. Obviously, human resources generally is useless. That's my personal opinion, but ideally, they were designed 70 years ago to be cover for corporations to clean up their mess before it became public. They still operate within that framework today, meaning you go to HR and they don't necessarily try to correct the problem. They try to cover up the liability of the company and protect the company first and then help the employee second if they so choose to do so. Other times I'll just laugh at the employee and not take them seriously at all. We see that day in and day out. It's quite upsetting, but it is the reality we live within. Let's talk about slide 7 now. That is your rights you have to challenge your employment termination. So basically, you can file a complaint with the EEOC if you believe Title VII was violated. You can also file an age discrimination claim with the EEOC. They have statutory jurisdiction to investigate the merits of both. Now, often they will look into the merits of the claim, and absent, really a bucket of evidence, what they'll do is write back eventually saying, well, we looked into it, and unfortunately, there's not much we can do, so you have a right to sue. The way I would equivalent that to is, imagine the IRS contacting you out of the blue saying, hey, Mr. Timmons, did you pay your taxes? Well, I'm going to respond with, well, of course I paid my taxes. Okay, great. Thanks for responding to our audit. We're glad to hear you paid all your taxes. We're going to close the investigation now. The IRS would never do that. Well, that's what the EEOC does with employers. They usually contact the employer and ask them, so is it true that you don't like people who are of Hispanic origin? And the employer is going to respond with, predictably, of course, oh, absolutely not. We love everybody in that characteristic. We don't engage in any discrimination. We behave perfectly fine. We have policies against that. Then the EEOC will close the claim and tell the individual, well, we couldn't find any evidence to work with, nothing we can do, but you have a right to hire a private attorney. If you get that right to sue letter, no, you have very strict statute limitations. You got to file a lawsuit within 90 days. So the timeline is very constricted. Additionally, there's Family Medical Leave Act, other laws, and Family Medical Leave Act, your rights under that require first statutory eligibility, and then going through the hoops to actually invoke it correctly. And if you're on FMLA, it's generally unpaid unless you have insurance to reimburse you. So I would encourage anybody who is in that situation, if your employer offers insurance, definitely consider signing up for short-term and long-term disability, because being on an extended duration of unpaid leave could cause financial impediment to your livelihood and really impact you collaterally significantly. Additionally, I want to talk about public policy exceptions to the at-will employment. So if your employer requires you to do something illegal or wants you to engage in an illegal conspiracy or some other unlawful activity, and they terminate you for refusal, that would be on violation of Texas law. And you can't be fired for refusing to go along with a criminal conspiracy. So again, those whistleblower protections also apply if you're a government employee. Also, you have a right to report to law enforcement any misconduct you think arises to that level. And as long as the report's in good faith, your employer can't make a retaliatory termination against you. If they do so, that's unlawful. So lots of things you can do to challenge your termination, but the key is documenting it as best possible. Just having a speculative theory about being maltreated is usually insufficient. You need to have some kind of notes, witnesses, statements, emails, and you need to have comparators also. So you have to show you're being differently treated. So one employer defense that we often see is the response of, well, we treat everybody terribly. So what? We didn't break the law. And generally, the courts are inclined to agree with that. So if you're working for an employer that treats everybody miserably, but they treat everybody equally miserable, then your continued compensation is almost seen as your acquiescence to the maltreatment. So keep that in mind when you challenge workplace conditions. Rights you have to challenge your termination continued. USERRA is the most paternalistic statute that I've ever come across when it comes to protections. This is the law protecting veterans. Basically, what that means is the burden shifts. I talked about Title VII already and how the courts have given so many exceptions to the rules that it almost swallows up the rule and kind of makes enforcement very, very difficult. USERRA is the opposite, meaning the employer has to show as an affirmative defense they took the action they took for a legitimate business reason unrelated to military service. Additionally, USERRA is strengthened considerably in some jurisdictions, such as Mississippi, for example, where it's actually a criminal violation for an employer to break USERRA. The manifestation of USERRA violations usually go something along the lines of, oh, you joined the Navy. Well, get out of here. You can't have divided loyalty. We need you here all the time, and I'm available 24/7. So how dare you join the Navy? I've actually had that exact case. That scenario is clearly unlawful, but employers that not aware of USERRA do that all the time. For example, I went to a Federal Bar Association Labor and Employment Law conference in Puerto Rico a few months ago, and Target had in-house attorneys there, and Target employs 500,000 employees. Thousands of veterans work for Target. I asked both of their attorneys flat out, so what does Target do about USERRA compliance? They looked at me and looked at each other, and they then asked me, what is USERRA? I looked at them dumbfounded, but not surprised, because they didn't even know what USERRA was. Obviously, a few minutes later, they Googled it and figured out, oh, well, yeah, we of course we love veterans. Well, that's usually the response you get. But the reality is most companies have no USERRA compliance protocols, no USERRA compliance whatsoever. They don't even know what it is. And USERRA has specific requirements such as when you return back from a mobilization or a deployment, they have to re-employ you, not just in the job you used to have, but in the position you would have had you never left. For example, if you're working at Kroger, which is a grocery store, making $10 an hour, and you're gone for a year and a half to Afghanistan, and you come back, and had you stayed, you would have been up at $12 an hour because you would have gotten step raises. Your employer can't put you back on the schedule and say, okay, go back to pushing carts, $10 an hour. They have to give you that $12 an hour salary because that's the position you would have had you never left. That requires a very, very case-by-case analysis. And that goes all the way up to, corporate directors and other positions that could be significantly financially advantageous. and harmful to the employer. They have to promote you if you were going to get that promotion if you never left. That requires a case-by-case assessment, and if they don't do that, then they're violating 18 U.S.C. 4301 in their failure to reemploy you properly. So not only does USERRA protect your job while you're absent up to 5 years, but it requires the employer to comply with what's known as the escalator principle and put you in a position had you never left. That most employers have no knowledge of that whatsoever. And I will say the worst offenders of that are municipalities, police departments, fire departments. They generally don't want to accommodate individuals who are absent. And I have noticed in the litigation, there's a lot of hostility within police departments between officers who are veterans and officers who are not serving in the military. I see that with pilots, I see that with fire departments, but for some reason I've seen it more common than anywhere with police departments. It's almost like if you're a veteran and you're entitled to veterans benefits, the police officers that aren't are very, very jealous and upset that you're getting preferential treatment, and they almost go out of their way to make life miserable for those veterans who are coming back. And it's quite unfortunate because the police departments almost never want to admit liability. And then they hire outside firms that are funded by the city and invoiced by the taxpayers pay the invoice, and they obstruct and obscure the issues for years and really treat the employees terribly. So that's just my own editorial of that situation, but I'm sure other employers are just as egregious in their violations. But there's a lot of individuals who serve in dual capacity as members of the Guard or reserves and as uniformed fire department firefighters or police officers, and they get the worst treatment that I've seen when it comes to USERRA issues. When it comes to, there's other laws out there. Texas Commission on Human Rights is a Texas agency that's has a job to investigate unlawful workplace activities, such as sexual harassment or discrimination and other unlawful employment practices. You have a right to file a complaint with the Texas Commission on Human Rights. Now, I will say Texas Commission on Human Rights, like most state of Texas agencies, is not sufficiently funded. They don't really do a thorough job. It's almost like the Texas Department of Transportation. If you report a car dealership for lemon law violations or other criminal statutory issues, running scams, generally they call the car dealership and they say, "Hey, a car dealership, are you running a scam?" And they respond with, "Oh, no, of course not." "Okay, thanks." And they send you back a letter saying, "Yeah, we looked into it, we did an investigation, no evidence, good luck to you. Go hire a private attorney if you want." That's the same thing with the Texas Commission on Human Rights. They do a very, very, lack of better description, not a full effort when it comes to enforcing the rules to protect individual employees. Same thing with Texas Whistleblower Act, a lot of lack of enforcement on that. And honestly, that's basically not because anybody doesn't necessarily want to do the job, it's just the agencies themselves are not funded up to the mission required. I mean, Texas has 30 million residents now, and our state agencies are funded at levels where they were 20, 30 years ago, when the population was about half of what it is today. So you have, half the population, the population has doubled, but the individuals to provide services has remained flat. So obviously they're going to be overwhelmed just by the sheer math of it alone. Whereas in other states like New York, where the population has been stagnant for 20 years, the size of government's actually grown. So there's actually more government enforcement per population than there is in the state of Texas. That's my discussion and my editorial. I'm going to turn it back over to my colleague, Mike Fallings, to finish this out here. Mike, please proceed.
Thank you, Sean, and thank you for all that great information. So our next slide is titled Payment and Benefits You May Be Due Upon Termination. So these are items that you may be entitled to, and you want to make sure that you are receiving before you're fully exited from the company. One is a final paycheck. The Texas law requires employers to pay their employees their final paycheck promptly. So if you're due your final paycheck for hours you worked, you want to make sure you receive that. I've seen situations where, employees are exited, but they're not paid fully for, the time that they actually worked. So you want to make sure that your employer, there's an agreement in place as far as when your former employer will pay your final paycheck. Next is the accrued vacation or paid time off. So this is leave, vacation time, paid time off, PTO, that you've accrued during your employment with your employer. Uh, it Employers have different policies in place regarding whether or not that is paid out. I've seen employers say we're not going to pay that out upon termination, and I've seen it absent. But you want to make sure you want to look at your employment agreements or your employer's handbook to see whether it's discussed. Otherwise, if it's not discussed, you need to demand that your accrued vacation be paid out to you. And that's equivalent to the sick leave payout as well. An employer may offer unused sick days upon termination. Again, the employers may have certain policies in place that say they're not going to do that, but if they don't have that, you need to discuss that with your employer to make sure that you're, taking advantage of your rights to get the accrued leave that you may be entitled to. Severance pay. So severance pay comes in when an employer is offering an agreement to separate. This is an agreement saying that you are being separated from employment, will agree to pay you this amount of money, and you agree not to pursue claims against us. The most traditional situation when severance is given is when there's a large layoff. Here in Texas and even in the Austin area, across the country, you've seen a lot of layoffs with the tech industry over the past year or so. And because of different business costs that have arisen due to the pandemic. And most of those situations, those employees were getting severance agreements and severance pay. Because their jobs were being eliminated at no fault of their own. It was due to the business structure and the business costs and everything like that caused them to release those employees. And they do fall under different scenarios as well, where an employer may decide, well, we are terminating your employment, but we'll agree to pay you an amount, so long as you agree not to challenge your termination. It's important to look at those severance agreements, look at the clauses like we, talked about earlier, and make sure you understand what's being agreed upon and what's being paid. Typically, severance is paid out based on how long you've been with the employer. If you've been there for only a month, that may be less than someone that's been there for about 10 years. So that's typically what employers may do, although some employers just have a standard severance that they may offer an employee as well. But it's, again, important to look at any kind of agreement that an employer's agreeing to pay you out on, because it's going to have clauses in there that may restrict your rights, which we'll get to here soon. The continuation of health insurance, COBRA. After termination, an employee is eligible for continued health insurance under COBRA for up to 18 months. It's important to know that. I receive a lot of questions on that as far as what to do about health insurance. And I understand that you're eligible, for the continued health insurance even after termination for that period of time. And that's a law that was enacted to help employees transition to their next employer and to ensure employers are still able to receive health insurance to protect themselves. Retirement benefits and retirement accounts. You need to make sure that you are getting any payment of retirement. You need to look and see what's been vested in your retirement accounts. If you are entitled to any kind of interest due because of your employment status with the company, any kind of bonus payments that may be due, you need to make sure and bring it up to say, hey, I was eligible for a bonus, this week, but I'm being separated from employment. When is that bonus going to be paid out? I want to make sure that bonus is still paid out. That bonus is typically based on, performance and your link with the company. And especially in a situation when you're being terminated, due to just business reasons, your jobs are being eliminated or whatnot, you need to make sure you're talking with your employer to make sure you're getting those bonus payments paid to you in a timely fashion. any retirement benefits, any contributions that's been vested on your 401k or whatnot. You want to make sure that's transitioned properly to you. And then we also have here unemployment benefits. You would have to seek unemployment benefits through the Texas Workforce Commission. The Texas Workforce Commission would determine whether or not you're entitled to unemployment benefits. But you're not prohibited from discussing that with your employer, that you're going to be seeking unemployment benefits. You may want to even discuss that, especially if you're being paid severance, because an employer may say you're not allowed to. We're going to challenge if your application for unemployment benefits. It may be wise to have a discussion through yourself or through an attorney you retain, to have a discussion about the employer not challenging your right to unemployment benefits. With the Texas Workforce Commission, they're going to make an evaluation on unemployment benefits depending on the nature of your separation. Whether you engaged in gross misconduct, may be a factor as to determine whether you get unemployment benefits. However, there are several situations in which employees are indeed terminated, but the Texas Workforce Commission determines that they're still entitled to unemployment benefits. So just understand that is a right you could seek as well, even upon termination. And our next slide here, restrictions you may have following your termination. So these are items that I've been referencing during my portion of today's presentation. So severance agreements, like I've talked about. These are agreements that an employer may offer to provide benefits to a departing employee, but they would want in exchange that employee agree not to file any claims of discrimination, harassment, wrongful termination against the employer. You need to review these agreements with a fine-tooth comb. Especially if you are thinking of challenging, your termination, and negotiate with the employer. If they're offering a certain amount of severance, you could ask for more. Especially if you have claims that you would like to bring, if you believe your termination is wrongful, you could ask for more. That's not a guarantee that the employer would agree to negotiate, but if you don't think the severance you're being offered is proper, then you need to not sign that agreement and challenge your employment termination through the avenues we've discussed. Other restrictions that could apply, especially if you have agreements that you're signing, are confidentiality and non-disclosure agreements. These are clauses and agreements upon termination that restrict you from providing the details of your employment or details of the company's trade secrets to anyone. And it also prevents you discussing the type of severance, the amount of severance. There are usually exceptions to discuss this with an attorney, your priest, family members, or whatnot. But going to the media or something, if you sign an agreement, saying you sign an NDA, non-disclosure, and then you may be prevented from going to the media or going to any coworkers, even former coworkers, about the amount of severance you got, about the reasons you were terminated. So you need to understand that and determine whether or not you should sign that or not. Non-disparagement agreements. These are clauses that prevent employees from making negative statements about the employer. This prevents you from going on Google, Yelp, or whatnot and leaving a review saying this employer was terrible. If you sign an agreement saying that your company that you work with was terrible, or your supervisor was terrible, you could be in violation of a non-disparagement clause in an agreement. So you need to make sure you understand that. And if you're willing to sign it, I always advise my clients to at least have it mutual, that they can't disparage you, that they can't, say about you to any future employer that you were terrible, or make any negative statements. So you need to understand those rights. I will note on the confidentiality and NDA clauses and non-disparagement clauses, the National Labor Relations Board has issued guidance in restricting employers from including broad clauses in these types of agreements. So, if you do have an agreement in place, I would suggest to consult with an attorney to discuss whether these clauses violate the NLRB's restrictions on what employers could do. We also have here not to sue clauses, which are clauses saying that you won't challenge any kind of anything that happened during your employment. You won't challenge that in court or with EEOC or with any administrative agency if you've signed an agreement. Those are clauses that prevent you from bringing any claim up until the date of your signature and regarding your employment against the employer. So if you sign that, that may prevent you from filing any kind of claims. So it's important to be aware when you see those clauses, to determine whether or not you want to sign it. And finally, non-compete agreements. Non-compete agreements prevent employees from working in a specific location or within a certain amount of time, following their employment with a specific employer. There's employers that will prevent you from going down the street, to work for, a company that does the same line of work. What's important here is employers sometimes keep these too broad. They'll say anywhere in the nation, or they'll say any line of business. It's important to understand that and challenge those clauses, because similar to, the non-disparagement and confidentiality agreements, there have been restrictions as of late that the governments have set in place to restrict employers from issuing these non-compete agreements that are so broad. They must be strict. They must be limited in what the employers could do as far as having these non-compete clauses and agreements.
In some states, Mike, just to add, like Oklahoma, I believe, have outlawed them entirely. And many state jurisdictions are moving to prohibit them, such as California and other jurisdictions. So if you have questions about the non-compete agreement, definitely consult a local counsel about the enforceability of the clauses in there. Many of them may not be enforceable.
Right. Yep. It's important to, yes, consult counsel if you see that in an agreement that you're given. So I think that ends our presentation. Now we'll open up for questions. I know we did get some questions prior to our presentation today, and I'm just going over some of these questions. Wrongful termination under false allegations violating my 14th Amendment rights. Well, I mean, not knowing specifically what's being asked here, I would say you should consult an attorney and potentially challenge your termination with the EEOC if you believe it was discriminatory. If you've been terminated, you believe it was based on discriminatory reasons, the EEOC, the Equal Employment Opportunity Commission, has jurisdiction over claims regarding discrimination based on race, sex, reprisal, religion, national origin, et cetera. So it's important to speak with an attorney or go to the EEOC regarding your claims. Not seeing, I see a general question about what to do, wrongfully terminated in Texas, and I think we've covered a lot of things you can do.
And Mike, I see a question about, can you join a labor union? And the answer is generally yes, you certainly can join a union, but there is requirements for unionizing at different work sites. So that's complicated and outside the scope of our presentation today, but generally speaking, you are allowed to pay dues to a union.
Right. And the other questions, federal employment administrative actions, this presentation is related to specifically Texas laws. The federal employment process is different as far as challenging terminations. So it's difficult to speak exactly on what's being asked here, other than that, the federal employment laws require, you to contact an EEO counselor within 45 days, or if you are a federal employee that has rights to appeal your termination with MSPB, you must do so, within a certain time frame, usually 30 days. But again, this presentation was really meant for Texas laws. If there's no additional questions, we'd like to thank everyone for joining us here today. We hope this presentation was informative. And like we've been saying throughout this presentation, if you are suffering from termination or anticipated termination, it's important for you to seek legal counsel. Here at Tully Rinckey, we do represent employees that are facing these types of situations. So, if you'd like, you could, contact our firm regarding your specific situation.